State versus Samantha Carter, 18383, charged with arson. Ma'am, do you have a lawyer?
No, sir.
Do you intend to hire a lawyer or make application to the public defender's office?
I need a court-appointed lawyer.
I'm sorry.
I can't. I don't intend on hiring a lawyer. No.
You don't intend on hiring a lawyer?
I don't have money to hire a lawyer.
Oh, okay, ma'am. You can make application to the public defender's office. If you qualify, we can appoint an attorney to represent you. Why don't you do that?
Yes, sir.
Okay. Ma'am, I'm going to have you reappear on September 20th for an arraignment and attorney status, okay?
Yes, sir.
There'll be an application at the jail. Fill it out, turn it in, and let's get you a lawyer, okay?
Yes, sir.
Okay, you can stand aside. Thank you. State versus James Stout, 18392, breaking or entering, theft of property. Good morning, sir. Do you have a lawyer?
Sir?
Do you have a lawyer?
No, sir, I can't afford one.
Can't afford one? Are you going to make application to the public defender's office?
I made.
Well, fill out an application. There's one at the jail there. Fill it out and turn it in. And I'll have you appear before another judge, Judge Webb, on September 13th at 9:30 for arraignment and attorney status. That's all we can do today. Thank you, sir.
Your Honor, I did fill one out. I submitted it 2 weeks ago.
You filled it out, okay?
Yes, sir.
Let me look here. Let me see if we can find it.
I was in here a week and a half and I was told I was arraigned, but I did not see a judge at that time.
Right. But the file doesn't reflect that you've been arraigned. Who did you give the application to, sir?
One of the jailers here, sir.
Okay.
I was in here over a week when I found out you had to actually request one via a form. So I requested a form and filled it out.
Right. Well, the public defender's office say that they don't have it. Do you remember the jailer you gave it to?
Yes, sir, I believe I do. It's either Raymond or Justin.
Well, at any rate, your case is before another judge, Judge Gordon Webb, so I'll have you appear before him, sir.
Okay, thank you, sir.
Thank you. 18384, Jason Holmes. Possession of controlled substances and paraphernalia. I was appointed to the public defender's office to represent you.
Thank you, sir.
How does he plead?
Your Honor, he enters a plea of not guilty. Judge, he has got a case that is pending on Judge Webb's docket. I don't mind this case staying on your docket, but it's a court. Okay, well, that solves the issue.
Reappear before Judge Webb on September 13th at 9:30.
Thank you, sir.
Here you go.
Thank you, Your Honor.
State versus Andrew Byer, 18379. Furnishing prohibited articles. Sir, I've appointed the public defender's office to represent you. And let's see. He's already entered a plea of not guilty.
Okay.
Your trial set for March 4th at 9 o'clock. March 4th, 2019, 9 o'clock.
Thank you, Your Honor.
You may stand aside. Thank you.
Okay.
State versus Ryan Kinsley, 18375, charged with furnishing prohibited articles. Sir, have you made an application to the public defender's office?
No, I have not.
Do you plan to do that?
Honestly, I'd like to get this dealt with today. If I could come over and talk to the prosecutor and just get it handled. I'm waiting to go to DOC, so I mean I don't want to keep coming back and forth. I'd rather just go to prison and stay there and not keep coming back to this jail.
Judge, the public defender's office could help on it if you want to bring it over later.
We'll transport you to the courthouse, sir.
I appreciate you. Thank you. Am I excused?
Yes, sir. Yes. State versus Lane Eggers, 18,369, DWI 4, some driving related offenses. I've appointed the public defender's office to represent you, sir.
Yes, I filled out the application last Friday and turned it in.
Okay, I'm gonna appoint the public defender's office to represent you. You've entered a plea of not guilty. Your jury trial set for March 4th of 2019 at 9 o'clock.
Judge, while Mr. Eggers is here today, I've spoken with the prosecutor about this. In district court last week, there was adjudication of his most recent DWI, and it was determined that was actually a DWI 2. So I think by the time this case is finally adjudicated, it will be either a DWI 3 or a not guilty, one way or the other. But because of that, I'm asking the court at this point in time to reduce Mr. Eggers' bond to $2,500 with the caveat, of course, that he won't drive or any other requirements the court puts on him while he's on bond.
What's the state's position?
And the most serious part of this is not that Mr. Edwards drives his vehicle while he's drunk. It's because the most serious part of this is he has no insurance when he does such a thing. And I don't know what, I guess you could, can you prohibit him from driving at all?
Well,
But he has no right to drive.
that's not working because I'm sure
Exactly.
he doesn't have a license.
Exactly.
Assume he doesn't.
No, he does not.
And he doesn't have a vehicle either at this point, Your Honor, based on the allegations from what happened here.
Judge, if he's on house arrest, perhaps that's what we need here.
Yeah.
I mean, he could go to, I don't know if the man works, so I don't know if he goes to the doctor. He can go to the grocery store, but I mean,
What's he do for a living?
Judge Lane, you don't work, right?
No, I do not.
He's retired. He lives way out south of town, and in fact, one day we had court, and it was 100 degrees outside, and he took off walking and made it almost to Mountain Home before I was able to get out there and pick him up. So I don't think a vehicle is going to be a problem moving forward, Your Honor. And of course, I will make it clear to
Judge.
him that he's not to be driving.
Judge, a DWI 3 is as you know, it's a Class A misdemeanor. There are people who get those. I just want some assurance that this man's not driving.
I don't know how to make that assurance
Right.
other than to keep him locked up, which you have to set a bond. I'll set it $2,500. Don't drive a vehicle.
Thank you, Your Honor. Lane, I'll be in touch with you, okay?
Thank you, sir.
Thank you.
State versus Mark Jeffrey, 18,317. Charge of possessing controlled substances. I'm appointing the public defender's office to represent you, sir.
Yes, sir.
You may stand aside.
Sir,
Yes.
I was gonna ask if, there's a way I can get my probation, violation dropped and maybe be OR'd. I've been here since the 26th, sir,
Yeah.
Your Honor.
Why don't you talk with your lawyer about that? I don't know anything about the probation violation.
All right, when do I get to my lawyer, sir?
Say it again.
When do I get to talk to my lawyer?
August, whenever they come to see you.
All right, so, would I be able to get OR today, sir?
No, sir.
All right, maybe a reduction of bond?
Well, take it up with Judge Webb. We're gonna transfer the case to him.
All right, thank you, Your Honor.
All right. Stephen Gunn, 16-207. There's been a petition filed to revoke the probationary period, son. What would,
Judge, we're going to enter a plea of true upon the recommendation that Mr. Gunn's probation be extended by a period of 2 years. He's actually already been discharged from probation, but the petition was filed prior to that happening.
Has he paid everything? I assume he has.
No, that's why they're wanting to have time to pay the rest of these off. We're gonna pay a couple $100 in the next
Just
week.
out of curiosity, how was he released from probation if he hadn't paid off?
So I guess the time runs regardless, but he's just delayed, you know. He flagged his time, you know. We filed the petition before he flagged his time, however.
What does he owe?
Yeah.
18, looks like $1,800 to the $1,800. He's been in jail for how long now? 25 days.
Why has he not paid since, year and a half?
Just, there's no good excuse, Your Honor. He didn't make the payments like he was supposed to. He's indicated to me now that he's put back on probation. He will.
And the state wants to extend his probation?
That's what they're telling me.
Okay. Sir, there's been a petition filed to revoke your probationary period. You understand what the state says you failed to do?
Yes, sir.
Are you pleading true that you failed to pay fines and costs?
Yes, sir.
You're giving up your right to have a hearing, your right to appeal when you plead true. You understand that?
Yes, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
Have you been promised anything to get you to change your plea?
No, sir.
Has anyone threatened you to get you to change your plea?
No, sir.
I'm going to revoke your probation. What was he originally convicted of?
Criminal mischief, Judge. It was a misdemeanor. That's why I was off probation, because it was a misdemeanor.
We can't extend it.
Can't extend it to 1 year.
Can I even extend it a year on a misdemeanor?
I assume since you could sentence him to anything, you could have sentenced him to, even if it was a misdemeanor, that you could sentence him to a year of probation. Is that correct?
He's already sentenced to a year probation.
Right.
What the petition that I have,
I can probably just hold him in contempt. There's been contempt citations before.
there's criminal mischief in the first degree, and he was placed on supervised probation for 7 years.
I didn't represent him in this. I think that Mr. Downey. Was it me? Yeah. It could be a typo too, Judge.
The police statement, that was what I was looking at. It says a year.
So we reduced it to misdemeanor.
That must have just, the original charge must have been
It was criminal mischief in the first degree,
Right.
which is a felony.
do you want us to come back to this, Judge?
Yeah,
Okay.
probably. You could put him in jail or forget about it. It's about all you can do.
Well, I don't want to forget about it, Judge. He took something from someone. He certainly hasn't paid him back. We'll pass it.
I'm not suggesting we forget about it. I was just giving the alternative.
Judge,
You may stand aside. (17-13) Heath Lindsay. Okay, sir, let's see what, the state's filed a petition to revoke your probationary period. Let's see how many we've got here. You understand what the state says that you did or didn't do to violate probation?
Yes, sir.
Are you pleading true to this,
Yes, sir.
to violating probation?
Yes,
For
sir.
doing so, you're giving up your right to have a hearing and you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Are you entering this plea freely and voluntarily?
Yes, sir.
Other than what's set out in the plea statement, have you been promised anything to change your plea?
No, sir.
And is it true that you committed an offense of theft by receiving and possession of firearms for certain persons while you're in probation?
Yes, sir.
Okay, I'm gonna revoke your probation. Let's see. Is there any recommendation?
5 years in the Department of Corrections, Your Honor.
Okay. on residential burglary, you're sentenced to 5 years in the Arkansas Department of Corrections. For aggravated assault on a family member, you're sentenced to 5 years in Department of Corrections. You pay $200 in cost, a $2,000 fine, a ZNA fee of $250, $20 booking fee, $200 in public defender fees. You'll be given credit for any sums you've already paid. Pay what you owe at a minimum rate of $100 per month, beginning within 60 days after your release. There you
Thank
go.
you.
Thank you. State versus Christopher Gregg, 14-87. Sir, I'm looking at a police statement here. Have you gone over this statement?
Yes.
And these conditions of suspension or probation? Okay, now you've gone over these documents and signed each, is that correct?
Yes, Your Honor.
Do you understand what's set out in these
Yes, sir.
documents? Do you understand the charges against you and the range of
Yes.
punishment if you're convicted?
Yes.
Are you pleading guilty to possession of drug paraphernalia, felony, and also possession of drug paraphernalia and misdemeanor?
Yes, Your Honor.
By doing so, you're giving up your right to have a trial, and you also give up your right to an appeal. Do you
Yes.
understand that? Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
Have you been promised anything other than what's set out in these documents?
No.
Has anyone pressured you or threatened you that you change your plea?
No, Your Honor.
Are you pleading guilty because you're in fact guilty?
Yes, Your Honor.
What happened here?
Your Honor, this arises out of a traffic stop that occurred on August the 8th of this year near Jordan Road toward Highway 5 South. This gentleman was stopped by law enforcement officers from the Norfolk Police Department and found to be in possession with a pipe used to smoke marijuana and syringes used for the ingestion of methamphetamine.
Is that true, sir?
Yes, Your Honor.
At this time, I accept your plea and judge you guilty for felony possession of drug paraphernalia. You're sentenced to 6 years in the Department of Corrections with 3 years suspended. For possession of drug paraphernalia misdemeanor, you're sentenced to 30 days in the county jail. You pay $200 in cost, a $2,000 fine, a DNA fee of $250, $20 booking fee, $200 in public defender fees, a drug crime assessment of $125. Pay what you owe at a minimum rate of $100 per month, beginning within 60 days after your release. Okay, what's to happen in a
We're
revocation?
going to dismiss the revocation.
Okay, so I'm gonna mark out that it's gonna run concurrent with the non process.
I'm bringing on process.
Okay, good luck, sir.
Thank you.
Jessica Schaefer, 18303, possession of controlled substances and drug paraphernalia.
Good morning, Your Honor.
Good morning.
Judge, Ms. Schaefer is here. We had previously discussed with the court, and I believe we were approved to have Ms. Schaefer enter the Care Center Ministries program here in Mountain Home. There's an issue of bond, I think, that's precluding her from being able to do that. We're asking the court at this point, I'm sorry, in time to allow her to OR. She has a probation violation for possession of a controlled substance and possession of drug paraphernalia. And she was on probation for the same thing. So we think that, and she believes that rehabilitation will help her in this matter. We set the revocation hearing out until November to determine whether or not she could be successful in that program. But the bond in both matters has precluded her from being able to get out.
Does she have anybody to sign a signature bond with her?
I don't believe so, because I think we had actually discussed that last time. Jessica, did we discuss a signature bond?
No, sir.
Do you have any family members here that would sign a bond for you if they didn't have to put any money up?
I'm not sure. My vision's bad, so I can't see. I don't know if anybody's there or not. Sir, I don't know.
Do you have a mother or a father here in town that we could get a hold of?
My mother and my father.
Okay. Do you think either one of them would sign a bond for you?
I couldn't answer that question, sir.
Okay.
I'd have to ask them
Why
first.
don't you let her explore that?
Okay.
Okay.
Judge, while Jessica's on screen, Jessica, could I have you give me a telephone number and a name for where I could reach your folks?
Yes, sir.
Okay. We'll give them a call. Thank you. Thank you, Your Honor.
Thank you.
State versus Lee, is that Willie or Wiley?
Willie, yes, sir.
Willie, 18-225. Breaking or entering theft.
Judge Lee has been in jail for, we're approaching 6 months at this point in time, and he's been unable to bond in these two matters. We are actively trying to come to a resolution. His trial is not set until November of this year. We're asking that the court consider a $5,000 bond to run concurrent in both of his pending matters.
Yeah, he had a bond.
It was $30,000, Your Honor.
This said 5,000.
Somehow, it's our understanding and the jail's understanding that it was at some point set at 30. So if it's a 5, that's fantastic.
Judge,
They
his bond
surrendered him.
originally was $2,500. That was when we arrested him in April. That's May 1st, 2018. And then while on bond is when he would have recommitted another breaking and entering and theft of property. This gentleman is a habitual offender. I'd ask, the state would ask that any bond would be a cash bond of $2,500.
I tell you what, apparently that he was surrendered and it was set at 30. I'll just leave it at that.
At 30, Your Honor?
Yeah.
This is yours.
Is it alleged he committed another crime while on bond?
He was in our jail on a theft of property charge. He was arrested, looks like, that information in 189. Oh, he was serving a 90-day parole violation. Okay, so he was on parole when he did it? Okay. Well, Judge, he was serving a 90-day parole violation. The man was on parole. On May 1st, my office charged him with theft of property and as a habitual offender. That was on May 1st. So did he not get?
It wasn't, I don't think it was charged until later, or there was an FTA, because this was filed May 18th. I don't think he ever got out of jail. Or if he did, it was for a very brief amount of time.
I guess it was long enough for it.
What did he do? The bondsman surrendered. Do we know?
Judge, if you'll let me look at that, I don't want to misspoke on that. He was told to reappear. His bond was actually reduced in that case to $5,000 by Judge Webb, and he was ordered to report probation upon release. And then he was charged with a breaking and entering. I want to make sure I can call the jail and figure out.
Oh, it says that co-signer said he was a flight risk.
Okay.
What the bondsman said.
Yes, sir, it wasn't a matter of an FTA, because I don't think these charges were even, the new charges weren't served on.
Tell you what, take a look at it. If it needs to be reduced, I'll consider it, for sure.
Thank you, Your Honor.
You may stand aside, sir.
Hey, Your Honor.
Yes.
Hey, is there any way I can request maybe come over this afternoon and maybe have this resolved?
Lee, I'm gonna work on it, okay? We're not really close to what we had talked about this morning, so if we get close to that, we'll bring you over, okay?
Thank you, sir.
All right.
Judge,
Have a good day.
I think that the issue was on May 10th, he did not appear, according to the notes on my file. He did not show up in this court. We have noticed it.